There are at least 3 things that can take away what you've spent a career building: a lawsuit, a long-term care event, and the wrong estate plan after you're gone. Most Ohio professionals I work with have thought about at least one of those. In my experience, very few have done anything about it. Not because they do not care about protecting what they've built, because nobody ever told them what asset protection actually means, what it can realistically do, and the part that changes everything: when you have to do it. This video presents a 5-strategy hierarchy every Ohio professional should understand, in order from the foundation up. Stay through the end. The time you roll at the close is the thing most people learn too late. I'm Andrew C. Goodwin, principal attorney at Rhodium Law. I help Ohio business owners, professionals, and their families craft estate plans that protect what they've spent a lifetime building. I didn't set out to become an estate planning attorney. I spent 15 plus years in IT before I went to law school. After that, large law firm work, then in-house counsel at a global health system, drafting and reviewing complex commercial agreements. But when the early days of the pandemic arrived, I recognized that my mother needed care. Memory loss, steady physical decline. I'd watched my father go through his own dementia journey years before, and I recognized what was coming. I stepped away from my career trajectory to become her full-time caregiver for 5.5 years. That season taught me something I did not learn in law school: what it actually cost a family financially and emotionally when the right structures were not in place before a crisis arrived. I built Rhodium Law from that experience, and that's why asset protection is baked into how I approach every engagement. Before I walk you through the 5 strategies, I want to be clear about what asset protection actually is. The term gets misused online sometimes, and a great deal of what shows up in search results is either too simple to be useful or too aggressive to be compliant. Here's a working definition. Asset protection is the legal work you do while you are still healthy, still working, and not currently facing any legal threat, in order to reduce how exposed your property would be if a threat actually came. Allow me to say that again. While you are healthy, while you are working, while there is no current threat. That timing is not a technicality. It's a central rule. Courts generally look unfavorably on asset protection moves made right before or during a lawsuit, a Medicaid application, or a creditor claim. That kind of transfer has a legal name, could be a fraudulent transfer, and courts have the authority to unwind fraudulent transfers. This is why I say asset protection is planning work, not emergency work. The strategies in this video are things you build into your legal and financial structure years before any threat appears. By the time you are served with papers or admitted to a memory care unit or named in a lawsuit, the window to act is generally closed. The second thing to understand: asset protection is not about hiding money or gaming the system. It is about using the legal structures Ohio and federal law already provide properly in the right order. Insurance, statutory protections, business entities, trusts, estate plan coordination. That's the 5-strategy hierarchy. Let me walk you through each one. Strategy 1 is the least glamorous and the one I have to mention first precisely because it's the most overlooked: insurance. In my experience reviewing Ohio professionals' plans, a pattern I see often is coverage that is not kept pace with net worth. A standard auto policy and a homeowner's policy with an assumption that's enough. For many households, that assumption is worth revisiting. 3 specific policies are worth reviewing. 1, an umbrella liability insurance policy. That would sit on top of your existing auto and homeowners policies and steps in when the underlying coverage is exhausted. If your household income is substantial enough that a plaintiff's attorney might consider you a meaningful target, an umbrella policy is generally worth reviewing. They are typically inexpensive relative to the coverage they provide. The right amount depends on your specific situation, but I encourage every Ohio professional to work with an experienced insurance agent to determine their number. 2, professional liability insurance. If you are a physician, an attorney, a CPA, an engineer, a real estate agent, or any other licensed professional, your malpractice or professional liability coverage is your first and most important asset protection tool. Review it annually. Make sure the limits actually reflect the scope of your practice. 3. Long-term care insurance. A long-term care event is one of the reasons Ohio families can deplete a home and retirement account they spent decades building. I will go deeper on this in the next video. For now, the asset protection point is straightforward. A long-term care event without coverage can significantly affect even a well-built estate. Long-term care insurance is one of several ways to reduce that exposure. The practical truth? Many sophisticated asset protection strategies have been tested by a liability that a basic policy would have covered. Check your insurance first. Strategy 2 costs you nothing. You already have it. The question is whether you know what it covers. Ohio law and federal law provide several automatic protections for certain categories of assets. Let me walk you through the ones that matter most to Ohio professionals. The Ohio Homestead Exemption. Ohio exempts a portion of the equity in your primary residence from unsecured creditor claims under specific circumstances. The exemption amount is subject to limits and is adjusted periodically. It does not protect against mortgages or recorded liens on the property, but for unsecured creditor exposure, a portion of your home equity in Ohio is generally shielded by statute. Retirement account protections. Federal law through ERISA provides strong creditor protection for most employer-sponsored retirement plans, 401ks, 403bs, pension plans. IRA accounts receive federal protection as well at a different level and with different caps. The practical point? Your qualified retirement accounts are typically among the most creditor-protected assets you own. This is one of the reasons I encourage Ohio professionals to work with an experienced financial advisor to evaluate whether maxing out qualified retirement contributions is the right move before turning to more complex structures. Life insurance cash value and annuity contracts. Ohio provides specific exemptions for the cash value of life insurance policies and certain annuity contracts under its insurance statutes. These protections are not absolute and are subject to conditions, but for many Ohio households, they are meaningful. And now, one Ohio-specific clarification that matters. A lot of generic asset protection content online talks about tenancy by the entirety, a form of ownership that, in some states, can protect property from the debts of just one spouse. Ohio's situation is more nuanced than most online articles capture, so let me walk you through it. Ohio briefly recognized tenancy by the entirety for real property between 1972 and 1985 when the statute permitted it. During that window, an entirety's deed protected the property from a creditor of just one spouse. Pre-1985 entirety's deeds remain valid for couples whose deeds were recorded during that 13-year window. But after April 1985, Ohio reformed the statute and replaced the entirety's option with what is now called a statutory survivorship tenancy. This is a different tool, and the difference matters for asset protection planning. A statutory survivorship tenancy gives married couples the survivorship feature. At the first step, the property passes automatically to the surviving spouse without probate. That is a useful probate avoidance tool, which I covered in the prior video in this series. But it's not the same as tenancy by the entirety. Under Ohio Revised Code 5302.20, a creditor of one spouse tenant can still enforce a lien against the debtor spouse's fractional interest. Once a court enforces that lien, the survivorship tenancy converts to a tenancy in common, and the creditor may obtain the debtor spouse's fractional interest. The takeaway? Ohio's current survivorship tenancy is a probate avoidance tool, not a one-spouse creditor protection tool. If you read about tenancy by the entirety as an asset protection strategy online, that article was likely either written for one of the states that still recognizes it or was written about pre-1985 Ohio deeds. For current Ohio asset protection planning involving real property, tenancy by the entirety is not available, and the survivorship tenancy that replaced it does not provide the same creditor protection. The takeaway for strategy 2, meaningful built-in protections exist under Ohio and federal law. Know which ones to apply to your specific situation. Build the next 3 strategies on top of that foundation. Strategy 3 applies primarily to Ohio business owners and real estate investors. If that is you, this is one of the most consequential categories in the hierarchy. When you own a business or a rental property in your personal name, every liability that business or property generates can potentially reach your personal assets. One slip and fall at a rental, one professional dispute, one really unhappy customer. If the asset is in your name, your home, your accounts, and your investments may be within reach of the same claim. The common solution is a separate legal entity. In Ohio, the most typical structure is a limited liability company, an LLC. When properly formed and properly maintained, an LLC is designed to create a liability barrier between the business or property and your personal assets. 3 things to understand. 1. The LLC only works if you treat it like a separate entity. Separate bank account, separate bookkeeping, documented business purpose. If you commingle personal and business funds or run personal expenses through the business account, a court may be able to pierce what's called the corporate veil and treat the LLC as though it were simply you. That eliminates the protection the structure was designed to provide. 2. Each rental property generally belongs in its own entity. Ohio real estate investors who hold multiple properties in their personal name or one shared LLC may be carrying cross-exposure worth understanding. A liability at one property can potentially reach the others. This is a conversation worth having with an attorney who reviews your specific portfolio. 3. An LLC is not an estate plan. This is an error I see in my practice. Someone sets up an LLC for asset protection purposes and assumes the estate planning question is answered. It's not. The LLC may be designed to protect the asset during your lifetime. It doesn't address what happens to that asset after you die. That's still an estate planning problem, and it still requires a will or trust or another coordinating instrument. Strategy 4 is where most people start. I'm listing it forth on purpose. Trusts can be meaningful asset protection tools, but they are more complex and more costly than the first 3 strategies, and they are most effective when built on top of a solid insurance and entity foundation, not as a substitute for it. Here's what trust can and cannot do for asset protection. A revocable living trust does not provide meaningful creditor protection during your lifetime. Because you retain the ability to modify it, dissolve it, or reclaim assets from it at any time, courts generally treat a revocable trust as functionally indistinguishable from your own estate for creditor purposes. When someone says, I put my house on a trust for asset protection, and they mean a revocable living trust, that approach generally does not accomplish what they think it does. Irrevocable trusts, on the other hand, are a different matter. When assets are transferred into a properly drafted irrevocable trust, you generally give up some degree of control over those assets. That trade-off, the reduction in control, is often what generates the protection. Different irrevocable structures serve different purposes. An Ohio legacy trust, a Medicaid asset protection trust, an irrevocable life insurance trust, and others. Speaking of, Ohio has a specific statutory tool for domestic asset protection. The Ohio Legacy Trust Act, codified at Ohio Revised Code Chapter 5816, authorizes a type of domestic asset protection trust called the Ohio Legacy Trust. This is an irrevocable trust that Ohio residents can use to help protect assets from future creditors, subject to specific rules and a look-back period. It's not the right tool for every household, and it doesn't operate as a blanket shield, but it is a real, expressly authorized option under Ohio law. The key takeaway: trusts can provide meaningful asset protection, but only the right type, drafted correctly, funded properly. This is not a DIY conversation. The difference between a well-drafted irrevocable trust and a poorly drafted one is the difference between protection and a false sense of security. Strategy 5 is the one most asset protection content skips. It may matter as much as anything else we've covered. The asset protection structures you build during your lifetime have to be coordinated with your estate plan, or they can fall apart at death. Here's what that means in practice. If you spent years studying LLCs for rental properties and your estate plan does not clearly address what happens to your LLC membership interests at death, those interests may pass through probate and unwind the structure you work to build. If you funded an irrevocable trust but your retirement account beneficiary designations still name someone you no longer intend to receive that money, that designation controls. Beneficiary designations override your will. In most cases, they override your trust as well. This is the coordination gap. The insurance has to work with the trust. The LLC has to work with the will. The beneficiary designations have to be consistent with the rest of the plan. And all of it has to be reviewed when life changes. Marriage, divorce, new children, new properties, new businesses, a move to a different state. In my experience, most asset protection failures do not happen because the strategy was wrong. They happen at the seams, where legal structures were built by different people at different times, and nobody made sure they connected. Approaching asset protection and estate planning as one integrated conversation tends to produce plans that hold up. Treating them as separate products tends to create gaps that surface at exactly the wrong moment. One more thing before I close, and I want to give this the weight it deserves. I mentioned the timing rule at the beginning of this video. I'm coming back to it at the end because it is the single most common point of failure in asset protection planning. Every meaningful strategy in its hierarchy has a timing requirement. For insurance, that window is straightforward to open. For built-in statutory protections, the window is always open. For LLCs, you need time for the entity to be established and operational before any issue arises. For irrevocable trusts, the timing rule is strict. Most meaningful asset protection trusts require a look-back period measured in years before they are fully shielded from a creditor challenge. For Medicaid planning specifically, there is a 5-year look-back period under federal law. I'll cover that in full in a long-term care video that's coming up in this series. The window is always bigger than you think, and always smaller than you wish. If you are currently healthy, currently employed, and not facing any legal or financial threats, you are in the optimal window right now. You have the most time and the most options. The further you move from that window, the fewer strategies remain available, and the more likely it is that any transfer you make can be challenged as a fraudulent conveyance. Asset protection is a stewardship discipline. It's not about fear or paranoia. It is about treating what you built with enough seriousness to put the right structures in place before you need them. I want to close with a way of thinking about this that I come back to often. A good asset protection plan is not about preparing for catastrophe. It is about building a legal and financial structure that is designed to be more resilient than whatever life sends against it. Every professional I know has seen it happen. A colleague, a neighbor, a family member who built something meaningful and then watched it erode, not from poor decisions, not from lack of effort, but because the right structures were not in place when a crisis arrived. A lawsuit nobody anticipated, a long-term care season that ran for years, an estate that went through probate because the will and the trust and the LLC were never coordinated with each other. The goal of this video is not to make you afraid of those outcomes. It is to make clear that most of them are preventable, and that the prevention work is well within reach of any Ohio professional who decides to treat it seriously. Insurance first, built-in protections understood, entity structure for business and investment property, the right trust layer where it fits, and everything coordinated with the estate plan, done before any threat is on the horizon. That's not paranoia. That is stewardship. If this was useful, please subscribe. I break down Ohio estate planning topics every week so you can make informed decisions before it's too late. I publish a long-form video that covers a number of topics that may be of relevance to your particular situation. There's a free resource linked below this video, the Ohio Professionals Asset Protection Playbook. It's a practical self-assessment guide that walks through the 5 strategies we covered today and helps you identify where your biggest exposures currently are. Just click the link in the description. One last thing, I am an attorney, but I'm not your attorney. Watching this video does not create an attorney-client relationship between us. This video is general information only, and it does not constitute legal advice. Asset protection strategy is highly individualized. What is appropriate for one Ohio household may be inappropriate for another. If your situation needs attention, please consult an attorney who will review your specific circumstances. Strategize, secure, shine, and I'll see you soon.